Yo, what's up? I'ma kick it with the line, y'all know. Yo, Slim, can I kick it like that? Here we go. Well, it's time to make that change. People of the world today are fading. All of us have our ups and downs. You better think about it or you won't be around. What we need is a little bit of love, sent by one from heaven up above. Chicken for tea is simple and plain. This ain't no game, you know what I'm saying? What? Yep, yep. Here we go. Oh yeah.
Well, it's time. It's time to make a change, and we are the people who can do it. Welcome again to another session of Success to Succeed on KBRG Digital Broadcasting with me, your host, Larry Harris. Today's guest is Sandy Bouzeron. She's a trust attorney and a state's attorney, and she also specializes primarily in handling estate planning and also guardianship. She's licensed attorney in the state of Florida, in the city of Miami, and she's here today to talk to our listeners about why you should have a will, why you should get a trust, or any other thing that would cause you to be better prepared to take care of an aging parent, to adopt a child, or do anything to manage your estate. Today, we are blessed to have her here. Sandy, would you please tell us about yourself and how you became a lawyer? And
Hi, good evening, Larry. Thank you so much for having me. It's a pleasure to be on the show tonight. I am an auntie, I'm an attorney, I'm an advocate for those on the autism spectrum, and I have spent quite a few years now working in the estates and trusts area, trying to educate families and individuals about the importance of putting these key documents together and planning for the expected life events that we all know are coming.
wow, that's good. That's good. What led you to become an attorney?
I actually was working for a nonprofit many years ago, and I came in contact with attorneys on a regular basis. So I was working, in the public sector, working with families on different things when it came to dependency cases. And because I was coming in contact with attorneys all the time, it was only natural for me to gravitate towards wanting to do that work. I was in the courthouse all the time. And so it was just something that I felt like fit with my skills and abilities. And I felt like I could do a great service in my community. My family is Haitian. And so I had a lot of clients that were Creole speaking, and they always had, attorneys that didn't speak their language. So I thought it was going to be a great thing for me, stepping in on that, because there were a lot of attorneys that didn't look like us.
Yes, absolutely, absolutely. What when you became an attorney? Uh, tell our listeners some of the stuff that you went through, especially being a female and African American attorney of Haitian descent.
Ah, man, it's an interesting process because, being a female attorney is one thing, but being a Black female attorney, and then on top of that, being a Black female attorney who is, I guess, non-traditional in her ways, it wasn't easy. You get a lot of flack from some of the other attorneys because they think they've been practicing for years, or they look at you like you're a kid. So, I went through quite a few experiences, and then the clients too. Sometimes they would look at you like, "Are you even old enough to be an attorney?" And mind you,
Wow.
I went to law school in my 30s, so I wasn't a little kid. But a lot of
Hmm.
folks, they expect their attorney to be a gray-haired Caucasian man, and so seeing this young Black girl coming up, it's not what people expect. So the respect level sometimes is a little bit in question.
Well, you know what? I remember in reading your bio, I saw that you are an auntie to a 14-year-old young man who has autism. And how would you say that helped you, as far as, I'm sure it helped you as far as patience in dealing with some of the flack and crap that you went through with some of these other attorneys that figure, well, I have more experience. I'm sure that, how could you kind of elaborate on how that helped you as far as moving into the legal field?
I mean, I think one, it allowed me to connect with families who had children that were on the spectrum, because what it did
Mhm.
for me was it opened up another practice area, something that I knew
Mhm.
that families could connect with me because I understood
Mhm.
their experience and I understood some of the things that they had to deal with a child who had autism. But the second thing was, in addition to patience, it just really taught me about just being able to adjust. You know, when you have a
Mhm.
child in your household that is nonverbal, a child that requires that special attention, it kind of makes you think twice when you're dealing with your clients. You know,
Mhm.
because clients are coming to me in their time of need. They need that special attention. They're not probably in their right, place in mind, and so they're vulnerable, and it's a
Yes.
difficult time. So it really teaches me a lot about having compassion, being able to really listen, and not just listen to what's verbally said, but also those nonverbal cues.
Yes. Yes. So, with that being said, how would you say that that leads into, knowing that people in the African American community, also in other, just people in general, besides the African American community, but people of color, they tend for some reason not to have a will. They tend not to know about trust. They tend not to know about things that can, um, save or guard their estates, or any property that they have. So
Right.
what are your feelings with regards to, getting, having people to come and see an attorney about getting, doing estate planning?
So being that I'm an educator at heart, I was an educator before I came into the law. I
Yes.
I work on the education piece. That's where my focus is, because I
Hmm.
understand that part of the problem is not just that people don't want to get it done or they just don't have it done. It's that they don't understand the importance, because it's always been thought of as a rich man's thing. This concept of planning and preparing, you have to have money to have a will. You have to have money to have a trust. And that is like the most false thing I've ever heard.
Hmm.
There are a lot
Hmm.
of basic things that you can put in place to plan for your affairs that don't necessarily involve the money piece just yet. It's really the plan that's the starting point.
Wow. Well, one of the things that I'm sure the listeners, those that I have friends, I'm sure there's people out there listening. They've had people that have, recently passed away, and one of the things I had a lady just tell me this other day. What is this about probate? If you could elaborate how what happens, how the process works. Is there ways to not have your estate go into probate? Maybe first by starting off, just keeping it simple, letting people know what exactly is an estate.
So, every single one of us has an estate. Right now, as we're sitting where we're sitting, every single one of us has an estate. An estate is made up of everything that you own in your name only, in your name jointly with others, everything that you potentially can receive as a beneficiary, but it's every single thing that you own. So, I'll start with some basic things: bank accounts, life insurance, your vehicle, your home,
Mm-hmm.
any other investments. If you're over there investing on Robinhood, those are all assets of your estate. They are the things that you own in your name. And so when it comes to the probate process, the goal of probate, it's a court process, and it allows for, when someone passes away, whatever it is that that person had in their estate, it allows for those things to be transferred to the proper individuals. If you have a will, those individuals are called beneficiaries. If you don't have a will, those individuals are called your heirs. And so the probate process allows someone to be either appointed by the court or allows someone who's a family member to petition the court and get those assets transferred to the right people.
Hmm. Well, let me ask you this: is it would you say that probate is cost prohibitive, or would you say, how what would you say in regards to the cost of when a estate goes to probate? Or
I
how
would
does it affect?
I would say that the value or the cost of a probate process could be a substantial amount in comparison to the estate value. So I'll give you an example. Let's say you have an estate where somebody has $5,000 in the bank. Here in Florida, for you to open a probate, in order for you to be able to get that 5,000 out of the bank account, it really depends. If you're doing a summary process, you're dealing with a couple of $100s to the court, but you're also possibly dealing with a couple of $1,000s of attorney's fees. So you could be spending out of that $5,000 possibly half of it, a quarter to half.
Wow.
Right?
Yeah.
Imagine if that bank account, all you had to do was make sure that you had a beneficiary listed. Soon as you do that, you've eliminated the need for that probate process, because that asset now is going to go directly to whoever you've listed as a beneficiary. So it can make a big difference, because you could literally, let's say you have an estate where you have a home and you have bank accounts and you have other things, and maybe the estate's worth about $200,000. You might spend 3%, 5%, 10%, 20% of the actual value of the estate just to probate it. Attorney's fees, costs, expenses, and God forbid if you have something like a foreclosure or a reverse mortgage or liens on property, those are things that can all decrease that pot. And so the point of estate planning is to minimize the depletion from that pot. Make sure that you can preserve as much as you can of your estate, so that that will now in turn go to your family. That's the whole concept behind generational wealth, leaving something behind that's not just going to be chipped away at by the courts and other fees and costs and things like that.
Well, for example, do you have any stories that maybe that without giving away someone's information, but especially naming their names, that you could tell our listeners about? Because I'm sure there's a lot of horror stories that are that you probably know of.
So I'm going to break it down by scenarios. So I'm going to give you this. Let's say mom passes away. She has 5 children. And when mom passes away, she leaves a house, she leaves bank accounts, and she leaves some investment accounts. Mom has no beneficiaries on any accounts. She doesn't have anything on her property that says who the property is going to go to. So you have 5 children that are going to be the heirs or beneficiaries. Now, if mom leaves a will, mom can leave instructions in that will of what her wishes are. So let's say mom knows that, child number 1 is my most trustworthy. Child number 2, I really want to provide for, but child number 3, nope, they have plenty of money. They don't really need anything from me. Child number 4, so and so on. If mom leaves a will, she can dictate that she only wants something to go to these 2 children, and she's going to exclude these because, they're already good. If mom doesn't leave a will, we're automatically in a place where the question becomes, was mom married when she passed away? If she was married, then her surviving spouse is now the person who's going to potentially receive her estate. And even without that part, if we're talking about the 5 children, depending on whether or not she was married and that spouse is the father of the children, that estate could be split 50-50, 50 for the spouse, 50 for the 5 children to divide. Right? If mom is not married, you have 5 kids that are going to receive these assets. And the biggest problem is going to be who's going to take care of the property. And the scenario that I see the most is there's 1 out of the 5 children who actually is paying the mortgage, maintaining the property. And then there's always 2 children. I don't know why it's 2. There's always 2 children who are taking advantage of everything, living on the property, don't want to pay anything, don't want to spend anything. They just want the money. So you imagine the conflict, and mess around and have one of these other children go and get their own lawyer. Now you have lawyer number 1, lawyer number 2, but there's only 1 pot with the assets. There's only 1 pot of money. So you imagine you're going to have an attorney's fees over here, attorney's fees over there. You're going to have one kid wanting one thing, another kid wanting something else. So it can become pricey. You could have an estate worth a few $100,000, And by the time you're done, each person might only get 10, 20, $30,000.
Wow.
And it really just depends on whether or not, everything goes smoothly. Because if there's a reverse mortgage, if there's foreclosure, if there's liens, that pot can be substantially smaller.
Mhm.
I'll give you another scenario. I tend to have a lot of out of state probates. So that means that family members live all over the US, somewhere else other than
Okay.
Florida. And so one of their loved ones passed away here in Florida. Nobody knows what they had, nobody knows what they owned, nobody has a clue. If we find out they own some property, typically what happens is the property is either in foreclosure or there's so many liens on the property. We need someone to say, hey, I'm going to go ahead and pay these taxes, or hey, I'm going to go ahead and do these repairs and take care of these liens. But most of the
Mhm.
time, what happens is you get an investment buyer that comes around and says, hey, I'll give you guys such and such amount of money. You guys can just sell this. You don't really need it. So they're going to give you whatever dirt cheap amount. You all are going to take the
Mhm.
little change, $10,000, $20,000, and they're going to flip that property for double, if not triple, of that property's value.
Wow.
Now, if
Wow.
the family was on one accord, everybody would get together. Each person might chip in a couple hundred or a couple thousand, do the repairs, pay whatever taxes or liens or whatnot, and then they could sell the property at the proper value if they wanted to. And
Mhm.
then they'd really benefit from getting some money from that. Or even better, how about repair the property and somebody keep it, maybe rent it out? Some
Yeah.
residual monies coming into the family, and each of you will get a percentage every month. We don't think
Yeah.
about that in our community. It's mostly probate happens, everybody just puts their hand out and they're like, I just want my piece. I don't care about the house, I don't care about all this other stuff. And now we're talking about sometimes, this is a family home a lot of the time. This is a
Mhm.
home that, the person worked very hard, and they blood, sweat, tears bought this home for their family. And as soon as they pass away, everybody's like, don't need that, let's sell it.
Mhm.
It's tough.
Yes.
It's tough.
So let me ask you this: Is there? Would you say? Well, I'm sure you would, but what would you say would be the preventative measures even before the loved one passes away? I mean, that's death is inevitable,
Right.
and nobody I know has cheated death yet.
No.
uh, so what could they do? Because I know, like I said, I know you do guardianship. I know you do estate planning, and that's another. And actually, guardianship is actually a part of estate planning because now with baby boomers coming, retiring, getting 65, 70 years old, and getting older, and things are getting reversed, where it looks like the children are taking care of the parents,
Right.
and that we have a lot of listeners that's happening to them now. How could you expound on that?
So, one of the major things that I wish every single family would think about is not waiting until mom or dad has Alzheimer's, dementia, until they're just unable to, until that person is in their end stage of cancer. Trying to do this planning in advance. Something as simple as a power of attorney can help a family tremendously. A durable power
Hmm.
of attorney, a living will and healthcare designation. These are those living documents that every single person, the moment you turn 18, you should have those documents in place, because anything can
Oh,
happen to you at any age. So the moment that you become an
wow.
adult, you should have these key documents in place, and you should be changing and adjusting your documents as things change in your life. So those simple things, when you have an elderly parent that you're taking care of, you got to get them done while they're capable, because the moment that they become unable to handle their affairs, they're not going to be able to sign over a power of attorney to you. And that's where
Right.
guardianship becomes an issue, because guardianship is pretty much like a probate process, but it's for a person who is unable to handle their medical decisions, their general well-being decisions, their physical decisions, and the court has deemed that there's an issue and someone needs to be appointed to serve as their guardian. And that someone could be a family member, but it also could be a stranger. And
Wow.
that to me is even more of the risk, because if you have a felony in your background, or if you have questionable issues in your background with, finances and things of that sort, you may not be
Mhm.
eligible to serve as your mother's, guardian, or as your father's guardian, or as your sister or brother's guardian. And it may be that the court has to appoint someone that doesn't even know your loved one.
Mhm.
So if I can't express enough how important it is to have some basic documents in place, those are the things that prevent going through probate and going through guardianship. It's thinking about, what do I need to have in place if my mom or my dad or my loved one is unable to do things for themselves, or even better, if my loved one passes away suddenly.
Right.
And we saw that a
That's
lot with COVID. We saw that a
oh,
whole lot with COVID.
absolutely. I know you said one of the things you said at 18 years old. Could you give an example at why someone would want, especially at 18? Because I know in a lot of states, 18-year-olds are considered adults. In some states, it goes to 21. So
Right.
could you kind of expound on that?
So whatever state you're in, the age that you become an adult, if you're able to, sign contracts and do certain basic things, you should have a power of attorney. And it's because of things like this. I had a situation once where it was a student that was in college that had passed away. Well, here's the problem. If mom or dad does not have access to your accounts, if mom or dad does not have access to your rent or your mortgage or any of your personal belongings, your information, they're not going to have access without a court order.
Yes.
Now, in some instances, they may be able to connect, because sometimes it's like, well, mom or dad is the one that signed the lease. So that's a different story. But I'm talking about, if
Mhm.
you own a bank account, your mom and dad can't just go into the bank account unless their name is on the account. They can't contact your
Wow.
mortgage lender and get information about your mortgage payments, or talk to the city about your liens on the property or anything like that. So if you're 18
Mhm.
years old and you have your own place, or you have, your own money and your own things, it's important for you to have someone. So if something happens to you, you'll have someone that can actually step in and, check on your bills and talk to your
Mhm.
doctors about your medical care. So it's an important thing to have in place, regardless of how, young you are, as long as you are of age that you can actually make those decisions.
Mhm. Okay. So my next question would be, for those, okay, we have a lot of listeners that are, they're young singles, and they're young married. And so I want, if you could take us on that spectrum with somebody, basically that's, say in their 20s,
Right.
30s, maybe in 40s, and then once they get married, some things that they need to do in regards to basic estate planning, and then also by the time they get of a certain age for retirement, as far as what are they looking at as far as estate planning?
Right. So young singles are the category of folks that I always have the most concern about, because I've had a number of cases where we can't even figure out where they had a bank account. We
Wow.
can't figure out what they owned, if they owned some property, if they had investments, if they were, in the stock market, if they had life insurance. We can't figure out what they had, because as many of us, young folks do, um, you may not tell mom, dad, and everybody else about your business. You don't have,
Mhm.
connections with them in that way. It's your personal
Mhm.
information. So imagine you have a child and they pass away, they're in their 30s or 40s, and they pass away, and you have no clue. You don't even know where they were banking.
Wow.
That's a difficult thing. So so I would say it's not just getting things like the power of attorney and healthcare documents or a will done. It's also planning out that information. You should have a list of all your accounts and your passwords somewhere safe. And you should have
Mhm.
someone that is aware of where that information is. So wherever it is that you
Mhm.
decide to tuck away your will and your power of attorney documents or whatever other, important papers, you should also have a listing of all, because we're in a technology age. Everything's
That's right.
electronic. So I'm not going
That's
to
right.
find letters in the mailbox that will tell me, all right, they had a bank account at this bank. So you now need to take the extra step of saying, you know what? I need to start jotting down a list of everything I own. Maybe putting the value down. If I have some valuable pieces like jewelry or artwork or things like that, maybe taking some pictures of those things, putting it somewhere safe so that if something happens to me, my loved ones will be able to say, all right, let me see. Okay, I see that she had a list of these things. Let me see where everything is and make sure I secure everything. But you can't do that if no one's sharing that information. So it's
That's true.
the whole thing about estate planning. It's a planning process, and it involves more than just preparing paperwork, because it's not the documents that's the planning. It's your mindset and the things that you put into place. That's the planning.
Wow. So how would you, okay, for people that are young, young married, if they're just getting married, what would be the first thing you would say for them to do as they let's say that a couple, they got married, and how soon after they got married would you say they need to start thinking about estate planning?
I think that should be part of their preparations for marriage, so that the moment that they get married, that they'll be ready to do certain things like get, their wills done and, any important documents, because you get married today. What happens if something happens to you tomorrow?
Yeah.
And if you're not having conversations with your spouse or your soon-to-be spouse about your financials, about your important documents, about what you own, you're already starting in a bad place. Because now if something happens to you, guess who's the next in line? It's your spouse. So,
right.
No matter the scenario, it's always at its core, what do you have in place in the event that something happens to you? Because something is always going to happen. The question is always when. So we know it's coming. We just don't know when.
Right. Absolutely. What would you say, how often would you say as a couple that they need to update that information and review it to see any type of changes they would make in a will or a trust?
So I would give two different times. The first time is anytime something changes. So if you buy a property, that's something important that you need to decide what's going to happen to that property if something happens to you. If you get some new investments, if you open some new bank accounts, anytime there's a life change or a financial change. And then the second point in time I would say is, you do your taxes every year, right? You look at your numbers every single year. That's a really good time to kind of verify, let me check and see that all of my beneficiary designations are up to date. Let me make sure I don't have someone that's passed away listed as a beneficiary, because that's a crazy area where those assets could become probate. If I put a beneficiary designation and that person dies, that's no longer a beneficiary designation. It's an account that doesn't have anyone to receive. So guess what? Your estate has to receive that. Okay. And that's it. As long as there's no language in their agreements that you have with whatever those financial accounts are, because some financial accounts will pay out depending on what it is to, like your spouse or something like that, or your children. But others, they'll pay it out to your estate. So they'll make the check out to your estate, and someone's going to have to open a probate to get those monies.
Okay. So, and while it's doing that, it's incurring fees, legal fees, and state and county tax fees for probate, right?
I mean, you're definitely going to get legal fees increasing as you wait to do certain things. And then, every state is a little bit different when it comes to certain processes in probate. Some nuances are a little bit different. I can only tell you that in Florida, the sooner that you do things, the better. The more that you let things linger and lag, you're going to find yourself incurring more expense and decreasing that pot of money or assets that you have in the estate.
Okay. And so what about also, a lot of times, especially in African American and people of color families, they will have they may not officially adopt a child or a kid, but a kid comes to live with them. And how would you say they need to how would that affect their family living situation as far as in estate planning?
Well, the key for that type of situation is if you actually want to leave something to someone who's not biologically your child, it's critical that you make sure that you put that information into a will. or better yet, if it's an account or something, or a life insurance or something like that, make sure that you put their information in the mix and list them as a beneficiary. Because the problem is, if you don't list them, they're technically not a biological child of yours. And
Mhm.
unless you adopted them legally, they're not your child. Even if if you hold them out to be your child. Now, understand every state has different laws and regulations, and sometimes there's some
Right.
nuances around this. But generally
Right.
speaking, if you're not someone's child, unless they've actually explicitly listed you, you're not entitled to technically receive.
Wow. So that means that if for example, someone came, someone had a child, and that child, they passed away, and the person that passed away had a will and said that they were in expectation of their friend or neighbor that wasn't a blood relative to take care of his child, and the person agreed to it, um, and they held them out as being their son or daughter. Legally, they couldn't. When that person passed away, they could not. This was specified that this non bloodline child is could receive anything. Is that correct?
Generally speaking, now I've seen some weird situations. Sometimes there's some laws that are put through, and some case law that shifts the game, because maybe the family knew this person to be a child of that person his whole life. Maybe he was listed on birth certificate somehow. We never know
Mhm.
what the circumstance is. um,
Mhm.
to be on the safe side, if that is your intention, you want to leave something to someone who's not biologically your child, then again, you have to keep in mind that the writing is what matters. If there's no writing,
Mhm.
we're going to go according to state law, and generally state law is going to go down those bloodlines.
Mm.
Okay,
Wow.
so it
Wow.
becomes tricky if you don't have a writing in place.
Okay. So then, as a couple ages, would you say or advise them to be setting up some kind of way so that if their children, say they were going into an assisted living, or if their children were going to take care of them, would you say that they needed to put something in writing, so like you said, to prevent, as a preventative measure, if they were getting like Alzheimer's? Because I mean, just off the top of my head, I can think of a couple of people I know where they were seen after. I mean, their parents were doing great, and then one of the parents developed dementia, which is like Alzheimer's, a part of Alzheimer, and sometimes they were there, and sometimes they weren't. And
Right.
so now, what in that case scenario, what would you advise?
They definitely need to make sure that they have paperwork in place long before we get to these stages. However, if you find yourself in a position where unfortunately mom or dad, or whatever loved one you're caring for, ends up having something like a dementia, Alzheimer's type condition, um,
Hmm.
guardianship is likely going to be your path. Um,
Okay.
Guardianship again is a court process also, and there's two pieces to it. One is to make sure that there is a determination made that this person is incapacitated. So it's one process in the mental health court. And once there is a determination made, then a guardianship can be had. The key with the guardianship process is understanding that the person is going to have rights until the court determines that they are incapacitated. So they're going to have an attorney appointed to them. There's going to be a panel of physicians that are going to do their individual reports and evaluations. And you'll have an opportunity to make your argument to the court of why you believe this person is unable to handle their medical and financial decisions. Now, keep in mind, the reason for the guardianship to be set up is to ensure that there's some oversight by the court of that
Hmm.
person's, monies, their person and their property.
Wow. So I guess it's kind of in the same vein. If they're, that sounds like something that they should prepare for even before such a thing like that happens. Such as if they had insurance, if the insurance is going to go to their state, if they don't have a beneficiary, then by
Right.
law, their insurance the profits from the insurance would go to their estate. Is that correct?
Generally speaking, yes.
Hmm. Okay. So what if it gets that far, is there anything that say a child of someone that's in an incapacitated state and they had that particular thing in place? Is there anything that they could do if it got to that point where that person, their parent was, if say they had two parents and both parents were incapacitated? I know you said about having a hearing. What is there anything that they could do to after it's happened? I know you said that they have to go to a mental court to make a decision about the judgment of the particular parent or the parents.
Right.
And then as you said, the children would make an argument in regards to about the mental state and things that they witnessed with regards to these. Is there anything that the children could do, like a clause or something of this nature, in like say a living will or a oral will?
Well, I mean, the children, you're talking about the children of the person who is incapacitated.
Yes.
I mean, there's not really much that they can do in terms of making any changes to, their parents' documents. The key to understand is, the guardianship will be in place to appoint someone, whoever it is. It could be one of the children, it could be multiple children, but the guardianship would be in place to make sure that someone is appointed who is going to be receiving some kind of court order that gives them the authority to do certain basic things with court approval. So they may have a budget that, every month they have to pay these bills and, they get a budget and then they have to take a court order to the bank every month, or, they may have certain activities that they're going to have to perform, like, checking up on them at the nursing home, or, managing any, caregivers and things like that. So it's almost like you have a job. That's what I almost feel like describing it. It's like you're a case manager for your own parent or your loved one.
It sounds like it. A job. I this is really something I had a question that was texted to me, and the question is asking, what if it says, what if the parents are if the parent is living with one of the other siblings, and they want to, their assets would be depleted if they were to they spend their assets on getting care and that kind of stuff, but they could actually apply and get what they call Medicare or Medicaid. Is there any way to protect those assets, or to either put those assets into a trust or a blind trust, or what type of trust, if any, could they do so that parent could be eligible for that type of aid?
So the type of process that parents typically go through to qualify for government type assistance is typically what they call Medicaid planning. Generally speaking, there's certain things that Medicaid counts as assets. And then there are certain things that you can do by, working with an attorney who specializes in Medicaid planning, to protect certain assets. Because, you're entitled to generally have the home that you live in. You're entitled to generally have something like a vehicle. There's certain things that don't exclude you from eligibility with Medicaid. And so, it's critical to work with someone who specializes in that. That's not something I specialize in, but I will tell you that there are there's a list of things that you generally can do depending on how much you need to qualify. And a lot of it is just based on, how much you're receiving every month in benefits, how much you have in the bank, how many assets you have and what the value of the assets are. Because the reason someone wants to qualify for Medicaid is so that Medicaid can pay for their medical care. Because, a nursing home, I mean, I have a couple of clients that are in nursing homes right now. Nursing homes can run a few thousand every single month to 7, 8, 9, 10,000 a month. You have different types of and levels of facilities. So
Hmm.
if you don't already have long-term care plans in place and you don't already have, a sizable pension or other monies coming in every month, many will have to qualify for Medicaid in order for them to have certain nursing care. So, I would say definitely if a trust is something that you're able to get done, early on in your lifetime, or even, at least before you get into your retirement age, it's
Hmm.
helpful because there's a lot of things that you can put in place into your trust and preserve funds, so that you'll have some money over the years to really handle your care. And depending on how your trust is established, some, depending on the level of assets, some may qualify still for Medicaid type benefits. It's
Hmm.
just it's a case specific type thing.
Mm. So it is a case by case basis.
Correct. Because it all
Okay.
looks at the dollars and cents. And depending on where your dollars and cents are, there's different strategies that different people are eligible for. But again, it is based on those individual assets and whether or not Medicaid counts certain assets or not.
Hmm. Okay. And the next question was, if you have a family and you have two children that are, as a matter of fact, one question was a child that's handicapped, and one of them says is they have autism, and what is the other? Oh, cerebral palsy.
Okay.
Is there, or so just in generally, if you had a handicapped child, because I know that you have experience because of your nephew, what how would you suggest that a couple or parents, how would they handle that or in their estate planning?
So the beauty with trying to plan for special needs planning is that you already know that you're going to need some, long-term care. So at least you have an idea already that I need to prepare for a long haul. The
Hmm.
difficulty is figuring out what types of things you want to put in place for your child, because the question is always going to come down to, how much money is it going to take to care for your child over the years? What type
Hmm.
of living arrangement is your child going to have? Are they going to live in a family home for their lifetime? Are they going to live in some kind of group home setting? Are they going to live with other relatives? Because special needs planning requires some attention to a bit of detail, because if your child is going to have monies, so let's say, for example, you decide to put life insurance aside for your child. If your child is going to have monies, then it
Hmm.
may be important to look into having a special needs trust or a special needs trust provision in their revocable trust.
Hmm.
Because remember that when you have a child with special needs, oftentimes many families receive some kind of support, some kind of benefits from the government.
Right.
And in order to
Right.
qualify for those benefits, it's important for that child to not be receiving an excess of funds, because those funds are supposed to assist them. There's certain funds that are supposed to assist them with certain things. And if you're
Hmm.
going to create a trust for this child, your trust is going to supplement what they're receiving from the government. So it's going to make sure
Hmm.
that they can travel, they can get certain treatments and therapies, they can, have kind of like, their social activities and the other things that they will need to pay for, because you have a special needs child, you may need respite care, you may need
Hmm.
transportation, you may need special caregivers, special treatments,
Yes.
equipment. Those are all things that would be supplemented by what you could put aside in a trust, because they're not going to be covered by the monies that you're going to get from any kind of government assistance. That's bare
Hmm.
minimum, right?
Hmm.
So you're going to need
Hmm.
a
Yes.
substantial amount. So the beauty is you can put some things aside and establish some supplemental needs trust provisions that will allow you to have monies that are basically seen as supplements to any kind of governmental funding. And the language
Hmm.
of that trust is going to allow you to be able to protect those funds for your child so that they'll always have those extra dollars to, keep them and care them in the long haul.
Wow. Well, before I ask you another question, I'd like for you to give your website and your an email and a phone number, or if you have Instagram, for our listeners, because we do have listeners in all 50 states, and also in other countries, if how they can get in contact with you if they had they want to get a consultation or if they wanted to speak with you in regards to what they're hearing on this interview.
Absolutely. Thank you so much. Again, my name is
You're
Sandy
welcome.
Boistron. I am with Spectrum Law Firm Miami. Our office is out of Fort Lauderdale, and our website is www.thespectrumlawfirm.com. You can also find us on Instagram at Spectrum Law and on Facebook at Spectrum Law Firm Miami PLLC. Oh, and
Very good.
let me see. I should give my phone number, right? I'm trying to remember.
Yes, that would be nice.
My number is nationwide 888-959-8264.
Okay. Do you charge for a consultation, an initial consultation? Is there a charge for initial consultation, or is it gratis? Is it free, or what's kind of your fee schedule for that?
So depending on the type of case, so for estate planning cases, we do charge a consultation. It really depends on whether they're sliding scale or regular. We also have, when it comes to guardianship, because I deal with a lot of special needs families, I typically do a 15-minute free consultation. And then also when it comes to probate, you're calling me at a time of need, so I do a 15-minute consultation. And then I just quote you the price for whatever the services that you're looking for. So, if anyone's calling my office from listening to this radio show, I will also honor that 15-minute consultation.
So basically they're calling you, telling you they heard it on KBRG,
Absolutely.
Digital Broadcasting on Success and Succeed, that you will give them a 15-minute free consultation. Is that correct?
Absolutely.
All right. Now, the next thing that I want to ask, because I know that you're good at this, is contracts. How, Success and Succeed, we have a lot of the listeners, they're entrepreneurs. And what would be one of the basic things you would say to them as far as dealing with contracts and about having an attorney on their team?
Oh man, this is something that I struggle with a lot because I interact with a lot of entrepreneurs on a regular basis because I'm an entrepreneur myself. And one thing that I learned over time is we don't do contracts. We don't prepare the stuff properly. We leave a lot of open-ended things and we think, I'm just going to go on these websites online and get these free forms. The problem is those free forms are literally just that, some free forms. You have to be able to input language that will protect you. And those free forms are not intended for your protection. And so I feel like for young entrepreneurs, for old entrepreneurs, we just don't plan out these things. And we think that we could just put a $sign and write a receipt and that's a contract. It's not it. You have to make sure that you have very clear, ironed out information. And if you're going to do a contract on your own, do your research. Go online, look up sample contracts, go to the library or go to the library online, pull out books on contracts. And if you're really going to do it yourself, then you need to put in that work to do it yourself. But I always suggest that you at least consult with someone. There are attorneys for every price bracket. So consult with an attorney about your specific situation and get some basic contracts in place. So if you sell a product or you sell a service, there should be some terms, some conditions, some disclaimers, some things that will protect you, protect your business. And then also, I can't stress enough the importance of having other professionals to work with. You should have an accountant once you start to make some money, or even before you start to make money. Consult with an accountant and understand what you're going to need to do so you don't mess yourself up for taxes and you don't miss out on these opportunities like PPP loans. Because many of us as small business owners and entrepreneurs did not take advantage of PPP loans. And they were a great opportunity for you to pay yourself a salary while you're trying to continue to build your business. So contracts, critical. If you don't have any contracts and you're doing business and you're collecting money, you are setting yourself up for liability. Complete. Like you're just opening the door for someone to sue you and you don't even have a piece of paper to say, look, Your Honor, this is what my contract said. You don't even have that. That's important.
Well, as an entrepreneur, what would you say would be the basis of setting up a team, and who would you have? Who would be the first person you would get on the team as
Oh man.
as an entrepreneur yourself?
If I were to go back in time and start all of this over again, the first person
Hmm.
I would have involved on my team would have been an accountant. The
Okay.
second person that would have been a part of my team was going to be a bookkeeper. And the third person would have been somebody to handle marketing. Any marketing, social media, promotions, event planning, somebody to really put out information, because we don't realize how important marketing is until we don't get any more clients coming in.
Okay. So that's the third person, and the fourth person would be the attorney.
Fourth person is absolutely my attorney. Actually, they might even be in the meeting with me and the accountant before we get going. They might be even more important.
Okay. So it's all about how you prioritize. Now, are you, as an attorney, are you working with any clients that did you by chance that were trying to get the PPP program, payroll protection plan program, or the EI is Economic Injury Disaster loan, EIDL loan? Or do you?
I did not work with any clients, in that regard. But I know, in talking to a lot of folks who own businesses, a lot of my colleagues who own businesses, many folks were like, "No, I'm not even gonna bother. I don't think I'm gonna even get it." They didn't bother.
Wow.
Yeah. I mean, it was a process. I understand that it was a process. I listened to folks talk about it during the first cycle as well as the second cycle. I know it was a process. It was a lot of paperwork and stuff to do. But one thing that it exposed was the fact that many folks don't have their books in order.
Mm-hmm.
And the core of the PPP program is payroll. So if you don't have a QuickBooks or a Gusto or FreshBooks or whatever it is to really organize your payroll and pay yourself as a business owner, you missed out. You missed out.
Wow. So you actually yourself, you went to another professional to see about it for your own self, all right?
We actually did it through our bank. So, I think it's important to have a great relationship with your bank, because they already know you. That's where all your money filters through. It was a process, even though we were doing it with our own bank. But, it worked out in our favor. So I think I saw a lot of folks talking about not receiving, but I also saw a lot of folks talking about that they received it. And it's a benefit because that's one less headache. You get a little something. It may not be a lot of money, but you get a little something to supplement your pay and allow you to continue to float, because the pandemic hit everybody in one way or another.
Right.
So
Okay. Again, I'd like for you to give your contact information. If you can be so kind to give that to us again.
Absolutely.
For those that didn't get a chance to write it down.
No problem. So again, I'm Sandy Boistron. I am with Spectrum Law Firm Miami out of Fort Lauderdale. And my main number is 888-959-8264. Again, that's 888-959-8264. Our website is www.thespectrumlawfirm.com. And you can find us on Instagram at Spectrum Law, or on Facebook, Spectrum Law Firm Miami PLLC.
Okay. Are there any words of encouragement or any words of advice that you would give to someone that is a new entrepreneur that you would say could definitely be of benefit to them? Like you said, if you had to do it all over and you had to go back and talk to the 20-year-old Sandy that's just starting out as an entrepreneur, is there any words of encouragement or anything you would tell our listeners?
I would say many of us have a lot of ideas in our head, and that's where they reside. Just start. Just start. Start something. Get it started. Map it out. Even if you don't have all the tools and the resources, we have the great old internet at this point. You can find just about everything that you need And you can
Yes.
start a business with $0 but your name. Just
Wow.
get it started. Open that Facebook page up. Once you start to make a little bit of money, figure out some things with your accountant, get your attorney in line, but just start it and
So
take that
basically,
leap.
it sounds like you're even starting with a sole proprietorship.
If they have to, sure. Because I know sometimes people are like, oh man, I have to spend a couple, $100 something to register a business and I got to do all these
Hmm.
things. If you have to, sure. But I would say if you're going to do it that way, please be careful about the monies. Calculate what you're spending, calculate what you're making, and make sure that everything, keep your receipts. Because what you want to do is take advantage of the tax advantage. You don't want to lose out
Hmm.
on, I spent all this money, but I don't know what I spent it on. Keep track of your expenses. There's a lot of apps and programs that will help you do that so that you can get the benefits, the tax savings of being a business owner.
Yes. Wow. So, because I know that as having a business, would you say that there was some almost like estate planning for the business? Because that would be another part in estate planning if the client had a business and it would be about who their share was going to if they were the owner of the business, and having that area in their will or trust mentioned, and then having that all worked out.
Yes, so there's something called business succession planning. And
There you go.
basically, it's making sure that you have all of your business documents in order, not just the operational piece, but the piece
Hmm.
that says, if I want to separate from the business, this is how it works. If I want to share my interest in the business, this is how it works. If I pass away, this is how it works. So it basically irons out, much like your will and your other documents do for you individually, it irons out your plan for your business interest and the
Hmm.
business operation as a whole.
Hmm.
So that's something to look
Wow.
into if you are a business owner, to make sure that you start to work on that. Google it, look at the paperwork, figure it out, talk to your attorney if you can. But you do have to do some things for your business to make sure that your operation just doesn't fall apart the moment that one of you becomes sick or something happens.
Okay. Well, you know what, Sandy? I really would like to have you back on the show and this is a short period of time, to have you expound on some things with regards to business. Also, tying the three together, knowing that you do estate planning, you do special needs, and you're excellent with contracts and about wills and for the probate. And that would be, if you're amenable to it, about having you come back on the show at a later date, and even set up
Absolutely.
something live where they can ask you questions. Uh, we can maybe run this in your particular on the Eastern Seaboard. I really appreciate you coming on the show and sharing your knowledge. You actually cleared up a lot of things. You've opened up people's minds so that they can see clearly now, and they definitely can see our obstacles in their way.
Hey, I love it. Thank you so much for having me. I look forward to being back soon.
All right, good to have you on. God bless you.
Thank you. God bless you as well.
I can see all obstacles in my way. Gone are the dark clouds that had me blind. It's gonna be a bright, sunshiny day. It's gonna be a bright, sunshiny day. I think I can make it now. The pain is gone. All of the bad feelings have disappeared. Here is that rainbow I've been praying for. It's gonna be bright.